Hello all, welcome. Today we will be covering the civil rights and qualified immunity case of Zorn v. Linton. As part of this video, we will cover the audio recording of the case and also cover the decision by the court at the end. The events of this case began on January 8, 2015, during a sit-in protest at the Vermont State House following the inauguration of Governor Peter Shumlin. Approximately 200 protesters gathered to advocate for universal health care, and when the building closed for the evening, a group of 29 individuals, including Shela Linton, remained in the legislative chamber. The protesters linked arms and refused to leave voluntarily, despite police orders. During the subsequent removal process, Sergeant Jacob Zorn applied a rear wristlock pain compliance technique to Ms. Linton to force her to stand and move. Ms. Linton alleged that this use of force caused her permanent physical injuries and psychological trauma, leading her to file a lawsuit under 42 U.S.C. Section 1983 for a violation of her Fourth Amendment rights against excessive force. The central legal question presented to the court was whether the Second Circuit erred in its qualified immunity analysis by failing to define the constitutional right with sufficient specificity, and whether existing precedent had clearly established that using a wrist lock on a non-violent, passively resisting protester was unlawful at the time of the incident.
The case of Zorn v. Linton, number 25297, was never actually argued before the Supreme Court. Instead, it was decided on March 23, 2026, via a per curiam opinion. In legal terms, this means the court issued its ruling by the court as a whole, rather than through a specific justice's signed opinion, and did so without holding formal oral arguments.
The Supreme Court issued its decision in this case on March 23, 2026. Because the court decided the case through a summary reversal, there were no formal oral arguments held for this specific docket number. The court ruled in favor of Sergeant Jacob Zorn with a per curiam opinion, meaning the decision was issued collectively by the court, rather than being attributed to a single author. In its majority reasoning, the court held that Sergeant Zorn was entitled to qualified immunity. The justices found that the Second Circuit had defined the clearly established law at too high a level of generality. The court emphasized that for a right to be clearly established, there must be a prior case with a close factual analog that would put a reasonable officer on notice that their specific conduct was unlawful. The court determined that the precedent relied upon by the lower court, Amnesty America v. Town of West Hartford, did not squarely govern the specific situation Sergeant Zorn faced, using a brief wristlock to move a protester who had been warned and was refusing to stand, and therefore his actions did not violate clearly established law. There were no separate concurring opinions filed in this case. However, there was a dissent noted by Justice Sotomayor and Justice Jackson. While they did not file a lengthy separate written opinion for this summary reversal, they expressed their disagreement with the majority's decision to summarily reverse the Second Circuit without full briefing and argument. They argued that the Second Circuit's determination that a jury should resolve factual disputes regarding the degree of force and resistance was a standard application of summary judgment principles and did not warrant the extraordinary remedy of a summary reversal by the Supreme Court. This concludes this presentation. If you have thoughts on this case and judgment, do comment below the video. Also, to receive notifications of future cases, be sure to subscribe to the channel. Please share the channel link with your friends and peers that you think may be interested in or benefit from it. Thank you.